Lovely. Thank you very much indeed, Karen. So, as you've heard, covering what is, I'm afraid, quite a complicated topic, so I'm going to try and keep it as interesting as possible and as light as possible. Broadly, what are we going to cover? Well, firstly, why is understanding these things important? And Karen has just touched on that to a certain extent. But essentially, you need to know about this, because if you're not doing it properly, it can cause some really very serious problems down the line. Then setting out briefly what the exemptions are, both from operating licensing and driver's hours rules, and then hopefully some tips on avoiding that particular crisis. So, why, in the first instance, is understanding them important? Well, this is a classic risk versus reward kind of area of regulation. If you do fall within one of the exemptions from operator licensing or aspects of driver's hours, brilliant. You don't have to worry about being licensed. You don't have to worry potentially about being dragged before the traffic commissioner and all of those kind of problems. However, if your case is not one of those clear-cut ones and your vehicle is stopped and they say, sorry chaps, I think actually you do need a licence, as Karen's just indicated, well, that might be your whole fleet off the road potentially until either an interim is granted, or if an interim isn't granted, a full licence. So potentially really serious consequences. But I'm afraid that might not be the only crisis, because as you'll see set out at the second bullet point here, there are criminal offences for failing to operate without a licence and for failing to comply or having the relevant vehicle fitted with recording equipment. So not only fleet off-road, but potentially criminal offences as well. So what are they? And here is where we get to the fun bit. You get some pictures. It's not all going to be law. The broad class of exemptions is created by Section 2 of the Goods Vehicles Licensing of Operators Act 1995, which I'm sure you're all familiar with and don't need a link to read. The exemptions are then specified in a set of regulations which are set out there. I note at this very moment in time I've missed off the S. It should be the Goods Vehicles Licensing of Operators Regulations 1995. And there are a number of exemptions set out in those regulations. And as I hope the pictures suggest, there are a range of vehicles that are covered by those regulations. So running through a few of these for you now, coming from Cornwall, my particular favourite, the tractor. In certain circumstances, tractors are exempt from operator licensing. It's only if, however, they're being used in accordance with Part 2 of Schedule 3 of the regulations. And that includes, for example, hauling threshing appliances, farming implements, or hauling within 15 miles of a farm or forestry estate occupied by the keeper of the tractor, material to be spread on roads to deal with frost, ice or snow. So you can see that these are fairly prescriptive exemptions. They don't always apply. And so you have to, as Karen was indicating earlier, check very carefully whether they do or they don't. So, secondly, our next picture, not specifically amphibious vehicles, you understand. That's intended simply to represent military vehicles, but more broadly, these are used, or those that are under control of, it's now His Majesty's, it hasn't been updated in the regulations, still says Her Majesty's, United Kingdom forces. So when you're out and about on the motorway, you see armed forces vehicles trotting around, not subject to operator licensing. I suspect not a problem for anyone here, but another interesting example. Thirdly, and the one that we will look at in a little more detail in a moment, your vehicle with MUPs, so mobile elevated working platforms, or as most people simply know them, cherry pickers on the back. Those vehicles over 3.5 tonnes might be exempt, and we'll work through in a moment an example as to why that might be. But what those are, according to the regulations, are vehicles fitted with a machine, appliance, apparatus, or other contrivance. It's a lovely word for you there, which is a permanent or essentially permanent fixture. And as I say, subject to certain restrictions. And perhaps finally, for this particular slide at the end, anyone tell me what that last picture is?
Steam.
Good man. So yes, paragraph 18 of Schedule 3, steam-propelled vehicles. I can't imagine that there are too many of these knocking around on the roads these days. The odd show, but it's nice to know that if on a Sunday you want to take your steam engine out for a drive, it's over 3.5 tonnes, no need for an operator's licence. So there are only a few set out there. There are 31 in total set out in Schedule 3 to the regulations. So if something unusual comes across your desk and you think, all right, this might be worth a look, take a look at the regulations. So taking you now through, I'm afraid, no picture on this slide, in a little more detail, this is where it gets a bit more complicated. The worked example for the cherry picker. So a vehicle fitted with a machine, appliance, etc., provided that the only goods carried on the vehicle are A, water, fuel accumulators and other equipment used for the purpose of propulsion or the running of the vehicle, loose tools and loose equipment. B, to be mixed by the machine, appliance, apparatus or contrivance with other goods not carried on the vehicle on a road in order to thrash, grade, clean or chemically treat grain. Again, you can see how specific this is. C, to be mixed by the machine, appliance, apparatus or contrivance with the goods not carried on the vehicle in order to make fodder for animals. Again, very specific. Or mud or other matter swept up from the surface of a road by the use of the machine, appliance, apparatus or other contrivance. Now, certainly B, C and D, you can see those are going to be very, very particular vehicles indeed. But A gives a bit more breadth here to what you might be able to include. So taking your MUP, your cherry picker, for example, if that vehicle is going out servicing street lights, etc., then you might say, we certainly fall with this exemption. We've got this permanent structure, contrivance, whatever you want to call it, fixed to the back of our vehicle over 3.5 tonnes. And what we are carrying in doing our maintenance of lighting columns, for example, falls within our loose tools and loose equipment, spare bulbs, that kind of thing. That is where you might fall within this. I'm afraid it is a might. These things are all fact and degree. If, however, you're going out on your large MUP vehicle and you're carrying a spare lighting column, for example, that might be seen as carrying goods, and it doesn't fall within any of those, and therefore you're not caught by the exemption. So I say this based on experience of looking at this. There is case law on this particular point. Previously it was actually British Gas, but carrying a large vehicle with a permanently affixed drill, very large drill at the back, used for drilling holes to put pylons into. This issue came up. The company was prosecuted. They said, we're not guilty, we're entitled to this exemption. Went off to the High Court for determination as to whether they were or not. And the High Court said because they were carrying a number of poles at any one time, driving around and sticking them in the ground, those were goods that weren't covered, and so they weren't entitled to the exemption. So you really have to think about whether these things apply very carefully before you do. Otherwise, I'm afraid the consequences, as I set out earlier, can be fairly dire. So, moving on to our exemptions and derogations from driver's hours rules, there is a distinction between an exemption and a derogation. It's set out in that first bullet point. It is, blessedly, quite straightforward at this point. Exemptions apply to journeys regardless of where the vehicle is driven within the EU. Derogations are national and thus apply to journeys wholly within the UK. So underline that, you need to be very clear on that. It has to be wholly within the UK. You can't pop over the border. Back in you come. Now, the exemptions are contained. I'm not even going to read it out, it's far too long, but the very snappily titled and part of retained EU legislation, but Regulation 561/2006, the full title is there, it will be in the slides that you get in due course. Thankfully, the national derogations are provided for in the slightly more snappily titled Community Drivers' Hours and Recording Equipment Regulations 2007. So again, what do these include generally? We'll come on to the worked example in a moment. Any vehicle with not more than 17 seats, including the driver's seat, crucial to remember that when you're counting them, used exclusively for the non-commercial carriage of passengers. So again, some really important points to pick up there. Is this vehicle, can my client, can the operator, can you satisfy yourself that it's exclusively used for non-commercial? You rent it out to a mate at the weekend, they take it off and pick up all the relatives from the airport, and they pay you for it. Not entitled. Would need to be covered. Any specialised vehicle which is being used for transporting circus or funfair equipment, also exempt or subject to this national derogation. And of course, again, not to the gentleman over there, any vehicle which is propelled by steam. So no driver's hours for steam-propelled vehicles. There we go. 18 derogations in total set out in the 2007 regulations, and those, again, I'm afraid are fairly complicated, and you need to read them quite carefully and double-check very closely that they apply completely to what's being said. Anything that takes you outside the derogation, that's it. It's a sort of bright line. You then have to comply completely. So, looking at the worked example here, and this one is one I think of the more commonly relied on derogations, but vehicles used in connection with sewerage, flood protection, water, gas and electricity maintenance services, road maintenance or control, door-to-door household refuse collection or disposal, telegraph or telephone services, radio or television broadcasting, and the detection of radio and or television transmitters or receivers. So these are split out into subparagraphs in the regulations. I've just collated them all here for you so you can see them. You can see they cover an enormously broad range of potential operations. The common theme with them is they are all, almost exclusively, matters that used to be done by the state in one form or another. Local authorities, central government in some cases. And so, whilst therefore it seems easy enough to apply them, I'm afraid because of that background, because they were originally designed for local authorities picking up rubbish from people's houses, the history of them makes them more difficult to apply than you might otherwise think. Because the changes that have come in since then, of course, is that these jobs are no longer simply carried out by local authorities, by councils, by the state. Plenty of these jobs are now done by private companies, private entities. And so there is a question mark, and I'm afraid it's unresolved. It's something that Mr. Turfitt, the Senior Traffic Commissioner, later, I shall be asking him about. But there's a question mark here that needs to be resolved, because operators want, obviously, necessarily not to be able to apply driver's hours in the way if they want to, but I'm afraid there is this complete misunderstanding at the moment as to how it works. So taking, for example, road maintenance or control as one where you particularly have a huge amount of private companies dealing with road maintenance and control, what they need to be able to show to bring themselves within this derogation is a need for a direct and close involvement in the exempt activity. So, what on earth does that mean? It means that when your road planer is out and is actually doing the road planing, it is brought within that derogation. So it is then doing its road maintenance or control aspects. But, and because this is a commercial entity, let's say doing it, any deviations from that will take it outside. So, journeys for your preventive maintenance inspections, positioning journeys potentially of the vehicle, mean that you are no longer entitled to rely on the GB hours derogation. You have to go back to applying the EU rules. So what does that mean practically if you're dealing with a client who has this question? Well, we'll come on to it in a bit more detail in a moment, but you need to look very carefully at how they operate, whether they can completely bring themselves within this, or whether they are going to have the odd journey here or there, I'm afraid, that takes them outside it. And then you're back to thinking about that risk of fleet being parked up, potential criminal prosecution. So I'm afraid, coming back to Carolyn's opening remarks, something that requires really very careful consideration and potentially taking advice if necessary. So, tips on avoiding crisis management, and I stress avoiding because we'd all like to, I'd certainly be out of a job, but if you can avoid the crisis in the first place, so much the better. So get on top of the issue as early as possible. If somebody is coming to you and saying, I'm thinking about setting up an operation, I'd like some advice on this, start working through it. Look at the exemptions from operator licensing. Look at the exemptions and derogations from driver's hours rules. Have them as part of your sort of flow chart of things I've got to work through and think about. If somebody's coming to you with a operation and saying, I'm worried about this, one of my competitors, for example, or colleagues mentioned this to me, or you've heard about it at a conference, potentially. Get on top of it early, get as much information in as you can. Because the benefit is, as I set out at the start, do they benefit from the exemption or derogation? Is there a way they can bring themselves within it? Because for some operators, their business model, particularly in relation to the driver's hours matters, may rely on them being able to operate in that way. I have seen some fairly scary examples of drivers who are exempt from the EU rules doing some incredibly long shifts. They don't see themselves as drivers potentially. If they are working in road maintenance, for example, they may well see themselves not as drivers, but simply as people who work on the roads. So that may require some real thought about operational shift if you actually conclude, no, you don't fall within this. You really need to think more carefully about how your drivers operate, how they record their time, etc. Heaven forbid you actually just need a license, full stop. So that means considering the issue thoroughly, in detail, and across all aspects of the organisation. As I say, you really need to understand every type of journey that an operator makes to be able to properly advise on whether they come within it or not. You take instructions and they come back and say, well, actually, we do have this vehicle out back that we only use twice a month or something. And you say, well, great, you're now firmly within operator licensing. It could just be that one vehicle. Might just be that one vehicle that needs to go on a license, but they still need a license for it. So be very aware of the complete fleet that you're working with. If unsure, and of course, point 4 here, my plug, Caroline's plug, do take legal advice because these things are complicated. Or, as I set out at the start, you have the potential for vehicles to be off the road for some considerable period of time, depending on what area of work your client is working in or you're working in. That might be the difference between continued success or your competitor taking your business because contracts have to be fulfilled and they go elsewhere just like that. And as I say, as I've warned a couple of times, the other potential is prosecution. Again, a bit turkeys voting for Christmas here, but no one wants to be prosecuted. I certainly don't want to see anyone prosecuted. So, making sure you think about these matters incredibly carefully when you're giving advice. If you're considering setting up a business that you think might be within these, very important to think about them well in advance and take appropriate advice if necessary. So, I will pause there to ask if anyone has any questions at this stage. If I missed Carolyn saying that we were doing questions all at the end, I'll happily defer. But otherwise, if anyone has any questions now, please do let me know. Otherwise, I think we are due a break, slightly earlier than expected.
Thank you very much, Mark. Any questions for Mark on exemptions or derogations from operator licensing or driver's hours?
Happy to ask them over a cup of coffee. People do want.
Now, Andrew got to get away, but does anyone have any questions for Andrew about retrofitting at this interval?
As it all applies to international journeys, you gave us the capacity for retrofitting within the UK. What's the European capacity for retrofitting?
Yeah, it'll be the same. The colleagues that I speak to across multiple European countries, we're all in the same issues. Majority of the issue might be supply. The tachograph manufacturers will boost up their availability for tachographs, but clearly not going to stop warehouses full. So like any part supplier, it's supply and demand. They will ramp up, but they want production and sales at the same capacity. So I would strongly recommend, like I said in the presentation, we need to start considering these retrofits now.
Any other questions?
I've got a question. Do you know if the DVSA have given any guidance on what they will do when vehicles are found if they haven't, bearing in mind the potential for an offence to be committed?
Come on up, Andrew.
Yeah.
You're looking too comfortable there.
Nice.
I think our UK vehicles are going to get prosecuted abroad.
Yeah.
So I think the problem that we're going to have here is how the DVSA see vehicles coming into the UK, which to my knowledge is a £300 instant fine and escorted to your nearest tachograph centre. Vehicle will be parked up and waited for the retrofit to be complete. The same rules will apply when we go into France, we go into Southern Ireland, them sort of places. Give you an indication, France is probably looking around about €3,000 instant fine and escorted to your nearest taco centre. That's then, I'm saying, retrofit kits within the UK, potentially ranging from £1,500, maybe up to £2,000. Instantly, you're probably doubling that going to France, knowing that you've been escorted and you've not really got another option.
Any last questions? So thank you very much to Mark Davies and also to Andrew.